Hi, my name is Amar, and this is Jennifer. Jennifer is an estate planning attorney, and today we're going to talk about the five most frequent mistakes that we see. Is that right, Jennifer?
That's correct. So
Yeah.
frequent mistakes we see, at least in my practice, with estate planning documents.
Yeah, awesome. So, like, the first one is failing to plan,
Mhm.
or simply just leaving it till it's too late, and unfortunately, not getting things done. And I have a pretty good example of this. I was working with a client once, and they did everything except in the healthcare directive and the power of attorneys. All those forms were blank,
Yeah.
and they never got it signed, notarized, any of that stuff. Fast forward a couple years, when I actually met them, they're actually going through a medical event, and they didn't have any of
Mhm.
those documents signed or
Yep.
notarized, but they had the trust piece done, right?
Yep.
So it's like, sometimes failing to plan or putting things off or not doing things completely can really get back at you later in life.
Correct. Yeah. I mean, we don't know when we're going to need these documents, so certainly having them in place. I meet with clients really frequently who have stalled the process over the years, or they have one particular topic or item that they just can't agree upon or figure out, and not doing anything is terrible. So
Yeah.
so I always counsel them, let's at least put something together that works right now, and then let's make a goal to review this again next year and
Yeah.
see if you have a better idea or a clearer idea or a different idea. But not doing anything is really the worst thing you can do. But there's an emotional, there's a psychological aspect to estate planning that can make these documents sometimes difficult to address and put in place, certainly.
Yeah, so I think the key takeaway there is it doesn't have to be perfect,
Yep.
but you just every time you review it, you can make some progress towards to making
Correct.
it ideal for you.
Correct. Correct. And that leads us to the next frequent mistake that I see is you put these documents together. I talk to clients about updating them. My typical recommendation is every 2 to 5 years, and anytime there's any major life change being births, deaths, marriages, divorce, anything big like that, a big asset change or event, and then tax changes. While I talk to clients about that all the time, I don't often hear. I'm not sure that they're they're doing it as frequently as they should. And
Yeah,
life changes, like we just said. You're putting these documents together. I just met with clients who put documents together in 2000, and they're like, a lot's changed in 22 years. And I said, yeah, it has. So, it's necessary to update these documents, not even for your own personal situation, but also just the law changes, and assets change. So,
yeah, like portability. Like I'm assuming
yep.
that person doesn't have the portability
No,
language because
yep.
it's
And
so
his
old.
spouses. So I talked to them and they had the three trust plan. And I was like, well, there's a new option that you can think about doing. So yeah, that was absolutely one of the things I talked to them about. It's also, you put these documents together when sometimes your children are very young and now they're adults. And are they thriving as adults? Are they struggling as adults? Like making sure, those provisions are up to date as well.
Yeah. And they have a different sphere of influence, right? Like they could have
Correct.
spouses and stuff like that.
Yes.
The
Yes.
other thing, I guess, moving to number three would be failing to fund your trust. And
Mhm.
so, like, you have this beautiful binder with all this trust language, and you find out none of the accounts have been put into the trust,
Yep.
right? And
Yeah. Yeah, and
and
that happens with a lot of frequency, unfortunately. So at least with my office, when we meet with clients, when the clients come in and sign everything, we try and have as much of the funding documents or asset transfer documents ready to go right at that signing appointment. So for the personal residence, additional real property. Assigning business interests, assigning their tangible personal property, but we don't really deal with the financial piece. So the banking or the financial institutions. So that's, yeah, sometimes the piece that gets forgotten. Also, we see with refinancing, what sometimes banks will require you to take the property out of your trust. You refinance, and then I can't tell you how many times clients are like, "I thought I put it back in my trust," and
Yeah.
we'll pull the deed, and nope, it's still in their individual names. So, I've done probate administrations where a piece of property was taken out of the trust for whatever reason and just not put back in, and it defeats the whole beauty and purpose of the trust to need to do a probate administration after that. So funding, um, some clients don't fund at all, which is terrible, or forgetting certain assets to fund into the trust. You need to be strategic about it. There are some reasons to not fund certain assets to a trust, but hopefully we're walking through all of that together with the client and making a strategic decision about that rather than just forgetting.
Perfect. The fourth one here is naming only one beneficiary on your trust documents. Maybe not having contingent beneficiaries. I know a lot of firms don't do per stirpes on their beneficiary forms, and that could be what you want or
Financial
intend.
firms, yeah.
And so I guess naming only one beneficiary forces you to be in a position where you can update your trust documents later in life. Sometimes that's not always the case. Right?
Yep.
So,
Yeah. So I just met with clients right before this, where it's a father and a son, and I talked to them about his contingent beneficiary, father's contingent beneficiary, if something happened to son, and he said, "Gosh, I don't really know who that would be right now. Can I just not say?" And I said, "Yeah, you can, but we just don't know."
yeah.
There's a blank in your doc. I mean, not an actual blank, but we always, as estate planners, talk about every possibility and eventuality, even though they seem unlikely or remote. Most likely what will happen is dad will pass away and everything will go to son, and everything will be fine. But including those contingent beneficiaries in there is really, really critical. So,
Yeah. Last one. Why don't you take this one, which is basically leaving assets to our minors, to
yeah.
minors.
So, and that has happened. I have dealt with that a couple of times, where there was a retirement plan, and they just listed a minor child as the beneficiary on that, and that created the necessity to go to court up in Ventura County and have a guardianship put in place to
No.
hold that retirement plan benefit, which was definitely not what the client wanted. But the client just really didn't think about the fact that they were listing a minor. And so certainly with any asset, thinking about either, is it a retirement beneficiary designation or life insurance beneficiary designation? Is it in the trust? Is it in your will? Because a beneficiary, if they're a minor, they're incapacitated. They are not legally able to hold assets. So options would be holding it in a trust for their benefit, and when they'll receive those assets, you can build into the document. You'd also do a custodianship account, where you're listing a custodian. It's kind of down and dirty. You list a custodian to be able to use whatever the assets are for the benefit of the minor, and you can typically put those out a little bit. So here in California, you become an adult at age 18. You can push custodianships up to 25 if it's inherited. Trusts you can do at any age. So it gives you a lot of flexibility to decide at what age or ages your beneficiaries are able to manage the assets. But you certainly don't want to list a minor, because that'll trigger a guardianship.
Yeah. All right. If you have questions or concerns, please leave it in the comments below. Please hit the like button, and talk to you next time. Thank you.
Thank you.